Extent of the injuries, any mental or physical pain suffered, loss of time of value, and reasonable expenses incurred for necessary treatment of the injuries for medicine, hospital, and doctors, and any other reasonable expenses directly or approximately caused as a result of the injuries the plaintiffs received in this accident. Okay. 225.
Yeah, they pay good too.
Okay. RPR 225 testimony. Ready? State your full name, please. Samuel Frank Davis. Have you gone by or been known by any other name? No, sir. That's the only name I have. You are the plaintiff in this lawsuit. Is that correct, sir? Yes, sir. What is your present marital status? I am married. Where are you living now? My address is 730 West Circle Drive. Where are you employed? I am a truck driver for highway transport. How long have you been working for them? Just since last April. What kind of work did you do before April? I was self-employed paint contractor. Before this incident took place in G.C. Murphy's store, had you consumed any alcohol? I drank 2 cans of beer. Where did you drink those 2 cans of beer? In my car on the way out there. Who was with you in the car? My wife was with me. Who was driving the car? I was. And did you have any other alcoholic beverage during the 12 hours preceding this incident? None whatsoever. What time of day was this? I don't remember, but it was about 30 or 40 minutes before this happened. I had the beer. Well, what time of day did this happen? I think it was pretty close to closing time. I know we didn't have but a very short time to shop when we went out there. What was your purpose in going out to the shopping center that day? To buy my baby some toys. Where did you intend to shop? My wife wanted to shop in G.C. Murphy's, and I didn't want to shop in there. Where did you want to shop? At F.W. Woolworth. It was cheaper there. After you parked your car in the lot, tell us what happened. We walked into the store. And then what happened after that? We were over there looking at some toys, and I told my wife I didn't want to shop in there. Tell us the next thing that happened. Well, Mr. Stone tapped me on the shoulder and told me I would have to leave the store. Did you do as he requested? I got my wife and started through the store. When I was almost to the door, he attacked me from behind. You say you got your wife? Yes, sir. She had her arm through mine and we were walking through the store. Who did you say attacked you? Mr. Stone did. Was he by himself? Yes, sir, and then he called for help. The next thing I knew, there were 4 of them on the floor, and he was sitting there beating me in the face. Who was beating you in the face? Mr. Stone was. Who were the other individuals? I don't know who they were. They worked for the store is all I know. What did they do? They held me on the floor while the man beat me in the face. What happened next? Somebody called the police, and they came out there and picked me up off the floor. The police picked you up? Yes, sir, they did. And then what happened? They carried me down to the jail. Where was your wife during this time? She was standing right there looking at it. Was she saying anything? Not that I can remember. The only thing I remember her asking me were for the car keys. And did you give her the car keys? She got them out of the pocket. I couldn't get my hands to the pocket. Did she say anything to the police officers? Not that I know of. Who were the police officers? I don't know who they were. But what did you tell them? I told them what happened, but it didn't do any good. They still carried me to jail. Where were you when Mr. Stone attacked you from behind? I was about 5 feet from the front door, 5 to 10 feet. I was almost out of the store. Where were you when Mr. Stone first tapped you on the shoulder? Back about middle ways of the store. What section would that be where they had the toys? Were there other employees around there? Any other individuals? I didn't see anybody. Where was your wife when Mr. Stone tapped you on the shoulder? Standing right there by me. She was looking at the toys and we were arguing about whether we were going to buy something. Were you arguing in a loud voice? I don't think so. My voice is naturally loud anyway. Were you using any profanity? No, I wasn't. You never used any profanity the entire time you were in the store? I never used any profanity. The only thing I told him was to take his damn hands off of me. Is that when he tapped you on the shoulder? No. When he had me on the floor. Did you ever use any profanity other than that? No, sir. And did you see any other witnesses around? I have a witness that went out there with us and saw it all. What is the name of the witness you are referring to? Her name is Jane Howard. Where was she during this period of time? Walking right along behind us when it all happened. But where was she when Mr. Stone first came up and tapped you on the shoulder? She was right down the aisle from us. About how many feet do you know? I would say 4 or 5 feet. What brought Mr. Stone's attention to you? I don't know unless one of the clerks told him we were arguing. You were arguing pretty loudly with your wife. I know my voice carries a lot, but We were just arguing about buying the toy. I just didn't want to trade in that store. Did you grab hold of your wife and try to get her out of the store? She walked down the aisle when he tapped me on the shoulder. Do you know how Jane Howard got to the store? She rode over there with us. What was she going to do in the store? She was more or less just shopping. I don't know what she was going to buy. Did Jane have anything to drink that evening or that day? Well, all three of us had 2 cans of beer. 2 cans of beer apiece on the way over there? That's right. Did any of you have anything to drink before you left? We stopped and got a 6-pack of beer. Each one of us drank 2 beers. Did any of you carry any beer into the store with you? I had an empty can. This is 180. No, I'm sorry, 200. No, 180 lit. Let's do a 180 lit. Ladies and gentlemen, you have listened attentively to the presentation of the evidence in this case and to the argument of counsel. We have reached the point in the trial when it becomes the duty of the court to charge you as to the law, which you will apply to the facts of the case. The facts you will determine from the evidence which has been presented from the witness stand and from the exhibits which are in evidence for your consideration. You will then retire to the jury room and arrive at a fair and impartial verdict in this case. There are 2 things that you must decide. First, whether or not the plaintiff is entitled to recover, and second, if the plaintiff is entitled to recover, what sum will be fair and just compensation for the injury she has received. In arriving at a fair and impartial verdict in this case, or in any case, there are certain well-known principles of law which you must take into consideration. First, during the trial of this case, it has been necessary for the court to make rulings on objections raised by counsel to the admission of evidence. Do not take the rulings as made by the court or the objections as made by the counsel as any impropriety on the part of counsel, or that the court may have a feeling that the plaintiff is entitled to recover or is not entitled to recover. It was the duty of the court to make the rulings which it made. It was the duty of counsel to offer the evidence which was offered, and it was the duty of opposing counsel to raise the objections to the evidence which was offered. You could well understand that there are differences of opinion between counsel as to what is or what is not admissible in evidence, and in protection of their clients' rights, it was their duty to take the actions which they took in offering the evidence, and of the opposing counsel in raising the objections to the evidence. Now, throughout the trial, you have heard references made to certain terms, and in the charge given by the court will make references to certain terms such as reasonable care or negligence or approximate cause. There are really not difficult terms to understand. Reasonable care, sometimes referred to as ordinary care, and each has the identical same meaning, is that degree of care which a reasonable or ordinarily prudent person acting under the same or similar conditions would exercise. As to proximate cause, an injury or damage is proximately caused by an act or a failure to act whenever it appears from the evidence in the case that the act or omission played a substantial part in bringing about or actually causing the injury or damage, and that the injury or damage was either a direct result or a reasonably probable consequence of the act or omission. Negligence may be defined as the lack of reasonable or ordinary care, or the failure to do what a reasonable and prudent person would ordinarily do under like circumstances, or the doing of an act which such a person would not do under like circumstances. In determining whether a person used due care or ordinary care or reasonable care, the test is whether he acted as a reasonably prudent person would have acted under similar circumstances. In this case, as in all cases, your verdict must be based upon surmise, conjecture, or sympathy for either of the parties, but it must be based upon the evidence which has been presented to you from the witness stand, the exhibits, and applying to that evidence the law which is given to you in the charge by the court. And the burden is always upon the plaintiff in cases of this kind to establish by a preponderance of the evidence the facts which are necessary to entitle a plaintiff to recover. Now, the term preponderance of the evidence does not necessarily mean the greater number of witnesses. It means the greater weight of the evidence, or that degree of proof which you find more convincing or worthy of belief. In ascertaining the preponderance of the evidence, or the greater weight of the evidence, and the credibility of witnesses, you may take into consideration the demeanor of the witness on the witness stand, his apparent candor or frankness, his bias, if any, his intelligence, his interest or lack of it in the outcome of these proceedings, his opportunity or lack of it for knowing the truth and having observed and testified to the facts which were related to the witness stand, any prior inconsistent statements if established by the evidence, and from all the facts and circumstances of the case you will determine the credibility of the witnesses and the preponderance of the evidence. It is not necessary that all material facts be proven by direct evidence. They may be proven by circumstantial evidence. That is, the jury may draw all reasonable and legitimate inferences and deductions from the evidence which has been produced before it. Ordinarily, an individual or a witness is not permitted to express his opinion, but there is one exception to this, and that is what we refer to as expert witnesses. Witnesses who, by education and experience, have become an expert in some art, science, profession, or calling may state an opinion as to relevant and material matters in which they profess to be an expert and may also state their reasons for the opinion. You should consider each expert opinion received in evidence in this case and give it such weight as you may think it deserves. If you should decide that the opinion of an expert witness is not based upon sufficient evidence and experience, or if you should conclude that the reasons given in support of the opinion are not sound, you may reject the opinion entirely. Now, the burden is upon the plaintiff to prove by a preponderance of the evidence that the defendant was negligent, and also to prove by a preponderance of the evidence that any such negligence was a proximate cause of the occurrence complained of. That is, that the occurrence was a natural and probably consequence of any such negligence. A person is not charged with foreseeing that which could not reasonably be expected to happen, nor for casualties which, though possible, were improbable. Burden which rests upon the prosecution, which is to prove the defendant guilty beyond a reasonable doubt. I will give you a definition of that term, reason. Determination in healthcare decisions. This is an important bill. This bill accomplishes a critical goal. It ensures that people are informed of their rights under state law to control decisions about their own health care, even when they are no longer able to voice their wishes through the use of advanced directives for medical care. Common law dictates that competent patients always have a right to refuse any and all treatment for themselves, even if doing so would certainly hasten death. If I am told I have cancer, I have a right to say I do not want chemotherapy, even if there's a chance that treatment could save my life. Religious teaching in the Catholic, Protestant, and Jewish traditions say that medical treatment is not morally required in every situation. General ethical principles buttress the idea of individual autonomy, thus the freedom of a person to make decisions for himself or herself. Good medical practice seeks the consent of patients before any medical intervention. Doctors face criminal sanctions when they treat an unwilling, competent adult. People clearly have an indisputable right to refuse treatment, and a patient should not lose that right if he or she becomes comatose or unconscious and terminally ill, or otherwise unable to make decisions. But that, Mr. President, is in effect what happens today. Our bill seeks to protect that right. 50 years ago, a bill like this would not have been so necessary. In 1939, only 37% of the population died in institutions. Most people died at home, surrounded by family and friends. Today, 75% of people are dying in hospitals and medical centers, possibly higher than 80% if we include nursing homes. More and more people can be kept alive even when they have lost consciousness and any ability to function. These advances in medical technology have forced us to ask whether and when we should limit the measures we take to extend life. Technology has also tended to wrest decision-making from patients. More and more, it is arguable that we play God by subjecting people to unwanted and sometimes unnecessary treatment. Treatment that unnaturally prolongs the dying process. Our healthcare system has become obsessed with extending life